Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we're continuing our series on the E-2 investor visa by focusing on the source of funds requirement, which requires that the E-2 investor show that the funds they invested into the E-2 business were lawfully acquired. Before we dive in, if you're interested in more information about the E-2 visa requirements, we've posted to our YouTube channel our full webinar on the E-2 visa. We also share a lot of free information about the E-2 visa and other visas on our blog. We'll link to both our blog and our YouTube channel below. Finally, please remember that no video or blog post can replace the value of working directly with an immigration lawyer who can navigate the specific nuances of your application. So let's take a look at the E-2 source of funds requirement. This requirement is very closely related to the E-2 investment requirement, which states that the E-2 investor must commit a substantial amount of funds to the E-2 business. The source of funds requirement emphasizes that these funds that are invested into the E-2 business must have been lawfully and legitimately acquired by the E-2 investor, and they must actually be funds that are committed by the investor to the business. Keep in mind that it's only necessary to prove the source of funds for the amount of money the investor invested into the E-2 business. If the investor invested $50,000 into the business, that's all that needs to be accounted for. As long as the funds are lawfully acquired, the regulations are very broad in terms of where the funds can come from. The money invested by the E-2 investor into the business can be from savings, income from work, gifts from friends or family, inheritance, a loan that's secured by the applicant's personal assets, or any other legitimate sources. In some ways, it's easier to instead provide the short list of legal sources that are not acceptable. One source of funds that is not acceptable is a loan to the investor that is secured by the E-2 business or its assets, since this calls into question the applicant's commitment to the E-2 business. Also, inheritance of the business itself will not satisfy the source of funds requirement. The applicant can inherit the funds that are invested into the business, but inheritance of the business itself is insufficient to satisfy the source of funds requirement. There is no geographical limitation on where the funds invested into the business can be from. They can be from within the U.S. or outside of it. In other words, it doesn't matter whether the E-2 investor saved money they earned from working within the U.S., from working in their home country, or working in another country abroad. As long as the work was performed legally, any of these locations is acceptable. So what documents should you include with your application in order to show where the funds invested into the E-2 business came from? For most consulates, it's sufficient to show where the funds came from and that they were spent on the E-2 business expenses. Let's take an example. Diego is applying for an E-2 investor visa at the U.S. consulate in Toronto, Canada. He spent $100,000 on the E-2 business, and he has the receipts and bank statements showing that he's committed these funds to the business. Diego saved the $100,000 from working a full-time job over the past 3 years. In his application, he will want to include his tax returns from the past 3 years, showing that he received these funds as income from work. He should also include payroll records, further showing that he did in fact receive these funds from his work. Since he's applying at a consulate, a sample of payroll records for 3 to 6 months would likely be sufficient. For those who are within the U.S. and want to apply for a change of status to E-2 through USCIS, it's critical to keep in mind that USCIS applies much higher scrutiny to the source of funds than most consulates do, often requiring that each dollar invested into the E-2 business is traced from its source to the E-2 business. In the earlier example, USCIS may expect to receive all of Diego's payroll records for the entire 3-year period. USCIS will also want to see that the bank account Diego used to receive his work income and then to purchase business-related expenditures maintained a balance showing that the funds did in fact come from his work income. Finally, if Diego transferred funds between his personal or business accounts, USCIS will want to see statements from each account showing the withdrawal and receipt of all funds, along with transfer receipts. In contrast to this, most consulates will only expect to see that $100,000 entered the account from Diego's work income and that $100,000 left the account to be spent on required business expenses. If you have incomplete source of funds records, applying at a consulate rather than USCIS could be a good choice for this reason. The source of funds can also be a business that the E-2 investor owns. In this case, it's important to include documentation showing that the E-2 investor owns the business that contributed the funds, and documentation showing that the business had the capacity to contribute the funds in question to the E-2 business, such as audited financial statements and corporate tax returns, for example. The applicant would also want to include bank statements and transfer receipts showing the funds moving from their outside business to the E-2 business. There are certain questions that frequently come up when discussing the source of funds requirement. One such question is whether gifts are acceptable. The answer is yes. We've handled many cases in which E-2 investors' investment came from a family member or friend who gifted the funds to them. In these cases, it's important to remember that it's always necessary to trace the funds to their source, even when the funds were a gift to the investor. As a result, the same documentation requirements that apply to the E-2 investor apply to the person who gifted the funds. This could mean that the person gifting the funds might need to provide their tax returns showing their work income, or documents showing that they sold a piece of property, for example, wherever the funds came from that they gifted to the investor. Loans are also an acceptable source of funds so long as they are not secured by the E-2 business or its assets. Remember that the investment must be at risk, which the government considers to determine whether the investor is truly committed to the E-2 business. As with other sources of funds, documentation is critical. You'll want to include in your application documents demonstrating the amount of the loan and its security. On the topic of loans, unsecured loans are also generally acceptable. One example of an unsecured loan is a credit card. We would advise caution if the bulk of the investment amount is on credit cards, since this could raise concerns by the government. However, it's not uncommon for E-2 investor applicants to place a portion of their E-2 expenditures on a credit card. Do keep in mind that as soon as you pay off your credit card bill, you'll need to account for where the money you used to pay the credit card bill came from. We hope this video about the E-2 visa source of funds requirement was helpful. If it was, please click the like and subscribe buttons to stay updated on future videos about visa options and travel to the US. Thank you for watching.